receive the education, and they have right to authorize practical training. They have right to travel, right to transfer schools, right to privacy. All these rights are there. But in terms of the SEVIS terminations, and in light of what's going on, to make it more clear that you also have right to seek legal help, you have right to challenge these terminations, you have right to request for reinstatement. If a reinstatement are denied, then within 30 days of that, you have right to file motion to reopen, motion to reconsider, and also take these challenge this termination in federal litigation, which we are going to discuss today in later part of our conversation. Now, if you're taken into removal proceedings, then you also have the right, if your immigration status is questioned, then you may have right to defend yourself in immigration court and seek other forms of relief there. So equally, you have right to be informed about why your service has been terminated, what are the legal responsibilities, your immigration options. Generally, when this scenario come, the idea is you should be able to, they should have provided opportunity to respond, the chance that about the violation, but these chances are not provided. You have no right to respond at this point where we're seeing random service termination. I would like to highlight that you have a right to due process before removal from the United States, and we are going to discuss that today. Now, with rights, you have certain obligations too, and we always say it loud that as an F-1 student, you should not be engaged in unauthorized employment. Do not work. Do not work until you have OPT, you have STEM OPT or CPT. Now, also, even for unpaid internship, it can be considered unauthorized employment if it's not properly approved by a DSO and the record has not been updated. So always be in touch with your DSO and only sign up with those unpaid internship after it being approved. Try not to fall below the full-time enrollment unless you have a prior written approval for that. Always keep your DSO informed about your change of address, your change of program, and any other things, and update your service record. Failing to report such things within 10 days may result in termination. So other things that I also would want to highlight is about keeping your passport valid, keeping your I-20s valid. If before it gets expired, try to renew it and make sure that the updates there are properly reflected. Your CPT, STEM OPT end date, and other details, you are supposed to look into it and make sure the informations are correct there. You should not travel without proper documentation. And most importantly, you should not be engaged in any criminal conduct. In current administration, as we are seeing that even an arrest, not just a conviction can trigger severe scrutiny. So avoid any such behavior that could lead to criminal or immigration consequences. Be proactive about your immigration status. Regularly communicate with DSO. And if you have received the service termination notices, don't ignore it. Take steps. Talk with attorneys, talk with DSO, try to explore your opportunities. There are legal relief, there are legal remedies available. So try to be proactive and take steps that you should take to protect yourself, to continue your dream here in this country. And I'll pass it on, so if she wants to add any points here.
Thanks, Avima. So I think you covered most of it. Just a few things I wanted to highlight. So there are some reports where students are just getting notices of their visa being revoked, but the SEVIS has not been terminated. So if you fall into one of those categories where only your visa has been revoked, but your SEVIS has not been terminated, then you're still in valid F-1 status. So your I-94 and your SEVIS is what determines whether you're in valid F-1 status inside the US or not. So just because you get an email saying that your visa is revoked, not the same as SEVIS termination. So, you are lucky that so far your SEVIS has not been terminated. It may be in the future, but for now, you're okay. You're maintaining valid F-1 status. So as long as you're in the US, fulfilling all the requirements of F1 student, like what Avima said, not attending, no unauthorized employment, attending classes full time, you have not received any SEVIS termination notices, you're fine. You're still on F1 status, even if your visa is revoked. And then again, the US government cannot just pick you up and deport you tomorrow. Like Avima said, there's process. So they have to start removal or deportation proceedings against you. And we will cover this later in the program. But remember, I know a lot of students all of us have been speaking to are very nervous about just being picked up, put on a flight, and sent to their home country. Um, it doesn't work that way. So you will be given due process. The government has to give you the opportunity to go in front of an immigration judge and fight your case. Just some common examples of like when there's unauthorized employment, like Uber is unauthorized employment, Lyft is unauthorized employment. Helping your friend make something and sell it on Etsy is unauthorized employment if you don't have a work permit. Going to your cousin's gas station and standing at the counter when they go to the bathroom is unauthorized employment. So try to avoid all of that, especially now. Um, yeah, that's all I have to add.
No, I think that's great. And Marina, before we go to you, I just wanted to quickly summarize the foundational understanding. If you are in a situation that you've got an email about your visa revocation, but your SEVIS has not been terminated, you are still in a valid F1 status. However, if you're in the other situation where your SEVIS has been terminated, and visa has been revocated, we breathe because we still have means, we still have rights, and we still have actions that we can take. It's extremely time sensitive, um, but it's you reach out to attorneys and you can start the process. So with that, I guess we'll go to you, Marina, and then, any of you can chime in. What are some of the common patterns in the types of students infractions that are being flagged in the current wave of SEVIS terminations?
So before we started, talking about the webinar, we did send out this Google form that participants could answer certain questions, and we received an overwhelming number of responses. And most of those responses, like what it seems to me from the data that we gathered, is that students seem to have some sort of brush with the law enforcement. In some cases, the involvement was a little bit on the serious side. But for most cases, it was very minor infractions, or charges that were filed but dismissed later, or the charges, or if some people were arrested but never charged with anything, or they were just in an accident and they had to give a statement to the law enforcement, or something along those lines, some very minor infractions. We did also have responses where they had DUI, which is a very serious offense, by the way, and then other types of like actual criminal behavior, which could be very problematic, obviously. But yeah, those were the reasons that we were seeing. For most of them, it was very minor infractions that led to like a SEVIS termination.
Okay, so with that sort of foundational understanding, right, we covered why we are seeing these SEVIS termination, why we're seeing the visa revocation. We covered, what are the basic rights of F1 students and what to be aware of. And we also kind of covered that there is due process and the steps that we can take. Now we're gonna go and define a little bit of key terms, so that you guys have an understanding of what those key terms mean as we delve deeper into some of the options after SEVIS termination, litigation, and the speakers will talk about specific cases, and what does that all mean when if ICE gets involved, and the support. So with that, I guess we'll start with you again, and we'll go backwards in Avima and Anshu in the way that they appear in my screen. Can you guys walk us through basic terms like what is unlawful presence and removal proceedings and notice to appear, right? Any of these terms that people will now have to acquaint themselves with as they get these letters.
So the very first thing that I would like F1 students to understand is the difference between visa revocation or visa itself, the stamp on your passport that you got, when you were granted the visa at the consulate or when you were trying to come in, between that and the status after you enter the country. So there is a big difference between the visa itself, the expiration, the validity of the visa, and the revocation of that visa. Your visa can be expired. Your visa could have been for like a year, but then it expired after a year. That does not mean that your status has lapsed in any way. As long as you're here in the US and as long as you're maintaining your status and maintaining maintaining your status by doing all of the things that you're required to do as a student, like taking the classes, taking the requisite number of credits and not working without authorization. And if you're maintaining all of those things, then you're in status. There is the visa revocation or its expiration has got nothing to do with it. The other thing that I would like to highlight is also the concept of unlawful presence. So you must have noticed that when you entered the US, when you came through the airport or wherever, you were given this form called I-94. And in that I-94, you will see that the validity period of your F-1 there's a notation called DS, which means duration of status, which means that there is no certain date in which you have to leave the country. Compare that to a B1 and B2 visa, like a tourist visa. You do have a limited number of days in which you are allowed to be in the country. So that usually is 6 months, and then you will see that validity period for B1 and B2 and other types of visas and things like that. But for F1, it's very different. It's like as long as you maintain your status, as long as you continue to go to school, don't work without authorization, don't do anything to violate your status, you can continue to be in status for years and years. Like you can continue to be on F1 for a very long period of time. I myself I think I was on F1 for like 10 years maybe when I started, college, and then like all throughout law school and everything, I was still on F1. So yeah, you can do that. And by regulation, the only agency that can determine whether or not you have any unlawful presence in the country is a judge, an immigration judge, or the USCIS itself. So if you have filed an application, let's say if you wanted to go from an F1 to an H1B or something, and then H1B was denied, you're no longer maintaining your F1, then that is a certain denial of your status. So like after that period of time, you might start to accrue unlawful presence. But that's very different from like, continue to maintain school and all of that. So the thing to worry about as far as unlawful presence is concerned is that it comes with consequences. So the statute provides that if you have more than 3 years of unlawful presence, more than 6 months but less than a year of unlawful presence in the country, and then you leave, you're barred from coming back in for 3 years. And if you have more than a year of unlawful presence in the country, then you're barred from coming back in for 10 years. So there is that 310 bar that you need to be aware of in terms of unlawful presence. But losing one's status by itself does not give rise to this unlawful presence that you should be worried about. And the other thing that I would mention at this point for students, I think their main concern is, am I going to be deported? Am I going to be arrested by ICE? Those are the main questions that we saw. Can I continue my studies? Like all of those questions. I am of the opinion that if the school allows you to continue, you should continue your studies. And because again, like SEVIS termination by itself is a very different concept than attending school. If the school allows you to attend classes, then you should continue just to take classes. In that sense, are you at risk of detention? Yes, I would say somewhat. I cannot completely say no, that you're not at risk of detention, not at risk of being placed in removal proceedings. That is a risk, which is why we will be talking about the litigation aspect of things and the removal proceedings itself and all those things. Well, we're going to talk about that later. But then Sammy mentioned notice to appear, which is it is the document that is sent by the USC. It can be issued by any agency, basically. It can be issued by ICE. It can be issued by the USCIS. It's a notice to appear in court, and the important thing to remember, I guess, for this specific situation is that if you have not violated your status, if you do not have any type of criminal conviction that would render you removable or deportable from the US, then you should not be worried about a notice to appear in court. Because even if you do get the notice to appear, the government still has the burden to prove all of those allegations against you, to show why you are deportable. So if they cannot meet that threshold, then the proceedings have to be terminated. And we can go into that detail a little bit. But yeah.
No, I appreciate that. That you gave us just idea of what notice to appear means, what are the implications, and how does unlawful presence triggered, right? Like now with that understanding and what Avima and Anshu said earlier about just kind of foundational understanding of F-1 and now the key terms, I think we're ready to delve into, now this has happened to you, your SEVIS has been terminated, you have gotten that letter, right? And I think all of you have sort of alluded to what that means, but now to go deeper into it, right? What are some of our options? Of course, there is reinstatement, and I'm going to let Anshu, you start with that and just kind of walk us through that and some other maybe miscellaneous legal options before we go into litigation.
Yeah, of course. So before we jump into the reinstatement, I just want to say that even though it's the government's burden to prove all of those things that Marina just talked about, if you get a notice to appear, you need to act. You need to talk to an attorney. Like you still need to show up in immigration court, and you need to fight it from your side.
Absolutely.
Even though they have to prove everything, you still have to take steps. Okay.
Yeah.
But you have very good chances of winning and overcoming that if, like Marina said, you've not violated your status, and this is obviously an illegal action that the government is trying to take against you. Okay, so you got the SEVIS termination email from your DSO. What are your options? So the first option that's available to you is reinstatement. If you meet all the requirements for reinstatement. So in order to be able to apply for reinstatement, that's something you apply with USCIS. You ask them to reinstate your SEVIS termination, basically, and your F-1 status. You have to file the reinstatement within 5 months of when you lost status. There are some exceptional circumstances exception to that, but we won't get into that. We are operating under the assumption that we're going to act as fast as we can. So file the reinstatement within the 5 months. You need a reinstatement I-20 from your DSO. So you need a DSO support to apply for reinstatement. It can either be the DSO from the school where you currently are studying, that can issue you the I-20, or it can be a new school. So if the DSO at your current school is saying we cannot issue you an I-20, you're going to have to shop around and try to find a school that's still willing to work with you and issue you an I-20. So that's a very important document that you're going to need for reinstatement. If you cannot get an I-20, you're not going to be able to apply for reinstatement. You also have to prove that you've had no unauthorized employment in the past. So you will be signing like an affidavit, a sworn statement saying that there's no unauthorized employment. And if you did have unauthorized employment, then that will disqualify you from reinstatement. You also cannot apply for reinstatement if you have applied many times for reinstatement before. So if you're somebody that does something and loses your status like every 2 months or every 6 months, that's going to be a problem for reinstatement. You also have to prove that you're either going to continue a full-time study or you're currently already pursuing the full-time study for I-20. While there's no requirement that you have to currently be in full-time school, it's highly, highly recommended to have a good chance of success that you continue to study while your reinstatement is pending. So you're allowed to do that, again, as Marina said, as long as your school allows you, you can continue your studies as though you still have valid F-1 status. The only things you cannot do when you have a reinstatement pending is you cannot work. So you cannot work on OPT and you cannot definitely not work on CPT, no on-campus employment. So those things you can't do, but you can study. Now, the other important piece of this is that you have to not have any other deportability issues in your record to be granted reinstatement. So again, we'll talk about this later on when we talk about what are some of the crimes that make you deportable. But basically, if you just have a speeding ticket or if you have a charge that was dismissed, you're fine to apply for reinstatement. And then, so these are the most important requirements you have for reinstatement.
Okay. What about OPT students? What about people who have, working or are currently on OPT? Is reinstatement an option for them?
Yeah, so this is one of the problems with reinstatement and OPT, that while your reinstatement is pending, you cannot work.
Mhm.
So for OPT students, they are most likely going to have to pursue litigation, which again, I think Marina will talk about later, but that's going to be the option for OPT students.
Yeah. And I'll also chime in that that's something you want to disclose to your employer. If that does happen to you, this is all uncharted territory, a lot of new things. So even employers are sort of figuring out how to go about it. That's also, if you are on OPT, that's when you do need an attorney consultation. You talk to your employer, you talk to an attorney, and then, they'd help you pave a path. But we did want to at least put it out there that if you're on OPT, reinstatement might not be as much of an option as it is for other people. Going to you, Abhimadi, just pretty quickly, or Marina, really anybody, how are the reinstatements looking right now? Like how fast, how's the process going? What are some of the struggles that you guys are getting?
I'll take this really quick. I think for most students, the issues that I have seen with reinstatement is that the DSO is not willing to reinstate the students, and they're having difficulty basically just getting another I-20 issued, like a reinstatement I-20 issued. That is the main problem that I see that students are having with the reinstatement. And reinstatement itself, it's filed with the USCIS. The USCIS has a very long processing time. It could take up to a year. And then, if the reinstatement, the process itself, the way that it's designed, it's meant for students who did go out of status for some reason, right? And the SEVIS was terminated for that reason. But it's kind of a weird situation where your SEVIS was terminated, but you didn't do anything to get that service terminated. So like, what is the reinstatement for? Like, how are you going to, like, what are you going to pick in order to, like, which option are you going to pick in order to request the reinstatement? So that's also um, like a problem with reinstatement right now.
So to step back a little bit, the pattern I've seen basically when speaking with these students and with the form that we have asked students to fill out is the termination cases, the reasons cited are otherwise failing to maintain status, individuals identified in criminal record check or visa revoked or unauthorized work. So basically, the allegation of unauthorized employment, and including those who have received a ticket for selling alcohol or cigarette to minor. And the other is the appearance of students in criminal record database, even regardless of the outcome, regardless whether those charges were dismissed, never filed formally, or involved in minor infractions, as discussed earlier. Now, if you look into the regulation by itself, I think as long as the student is pursuing a full course of study or engaging in authorized employment, it is supposed to be that they are maintaining their status, right? And the regulation says that the conviction of a crime of violence punishable by over 1 year in prison may constitute a failure to maintain status. But many students receiving SEVIS termination have no such convictions. In some cases, the offense, the Alice offense would not even qualify under this provision. So as Marina said, it's kind of tricky to get into the file reinstatement because the SEVIS termination itself is not clear. It's inconsistent with regulatory standards, and this lack of transparency has created a widespread anxiety because the students are uncertain what to do next, And now the other thing that I've been hearing is that in the SEVIS portal itself, they need to ask DSO, because I don't think all students have access to that portal. The DSO have access, so they need to ask DSO to send a screenshot of that, and also have to ask that if that reinstatement option has been grayed out or not, to see that if they are eligible to file for reinstatement. Be proactive, speak with your DSO about their willingness to help you get the reinstatement, and if they are willing or not. And I basically, when I speak with the students, what I realize is that because the termination notice itself is not clear about the allegation, the DSO are being uncomfortable to work with the student. So be upfront with them. If you have any criminal cases, if you have documents and they are dismissal, you have to discuss that with your DSO to convince them to be on your side, So to get the criminal record, unfortunately, many students I spoke even do not know the criminal charges. They were like, this was the allegation. I don't know what the outcome was. You cannot be ignorant like that. You need to be upfront about what happened to your case. Speak with your criminal attorney, go to the court, try to get the disposition. What is disposition? It's a final outcome of your case. It can show what the allegation was, what the outcome was. If the cases were dismissed, so to your DSO, ask them to be on your side and get that reinstatement application. So that's what I think with these minor criminal charges and infraction, students are kind of scared to discuss this with DSO. So either start discussing with attorney, get DSO, and act fast. Don't leave the country. I know that many colleges and DSO are asking students to leave the country immediately just by your service being terminated. You should not leave the country. There are steps that you can take. There is a due process. There will be removal proceeding initiated, and you can defend yourself. So we can discuss that later. But that's what I just want to add.
No, absolutely. And I think anytime you are going to make a big decision like leaving the country, do not do that without talking to an attorney, without at least giving it your best shot and looking at it from all avenues. And as we are discussing, there are other avenues to look at. And of course, nuanced as it may be, Anshu and Avima said that just going for reinstatement is not, it's not like I apply and I get it. There's nuanced approach to it. So it's important to understand the complexity behind it. It's important to understand that it's not a sure shot, but it's worth a try, right? So that's really great. So and now we've kind of discussed reinstatement. Let's look at some other legal options, right? How does marriage-based adjustment fit into this? What about other options like B1, B2, perhaps, right? Are those something that are viable options? So I will direct it to begin with Anshu, but Marina and Avima, please chime in as you go.
Yeah, so if you don't want to risk reinstatement since it's uncertain, then some other options are you can apply for a change of status back to B1, B2, and you can ask for something called non-protonc change of status, which is basically asking USCIS to treat your application as though you filed it as of the day your status was terminated. So B1, B2 is one option. It's obviously a short-term option because even if your status changed, you're likely only going to get 6 months to figure out next steps. If you're married to an F1's visa holder, you can also do the same kind of application, do a change of status to F2. Obviously, if you're married to a US citizen and you're ready to move forward with the adjustment of status process, you can file your marriage-based green card process. Now, for those that are married to green card holders, it will be a little more tricky. And you are going to have to make some arguments about how your application should not be treated as though you should be treated as though you fell out of status because through no fault of your own. But these are all valid legal paths that you can take if a reinstatement doesn't feel like something you want to move forward with. So B1, B2, change it back to F2. If your spouse has an H1B, changing to an H4, same type of arguments, or doing a marriage-based green card, marriage-based adjustment of status would be some of the options. And then obviously, we just told you don't panic, leave the country, but for some people, that might be a good option to try. So for example, like if you're married to a green card holder and your marriage-based green card petition, I-130 is already in the process, and your run-in with the law was something minor, like traffic, or case was dismissed, then you may want to leave and wait out the 1-2 years of green card, processing in the home country. That might be less stressful for you. So there are options. Doesn't mean all the options end here and with reinstatement, but these would be things you can speak to an immigration attorney about and then decide what makes sense for you and your family.
Thank you for that. Do Marina, anything else to add on that? Any risks of B1, B2? Anything you guys have been seeing? Trends?
I myself have not done a B1, B2. I mean, this is an unprecedented situation, of course, but that I do see that as a viable option, but it does give you, like Anshu said, it's a limited period of time. Like you cannot be on B1, B2 forever. Like, it's not like I said before, it's a date certain. Like you get 6 months or, and then you have to figure out like what you want to do afterwards. And obviously when you're on your B1, B2, if it does get approved, you cannot work. Like there's lots of restrictions on what you can do on a tourist visa like that. The other thing that I would say is just to add to Anshu's point. So marriage to a U.S. citizen and marriage to a green card holder, they are very different processes. So if you have more things to think about if you are married to a green card holder, because you do need to show maintenance of status. And which is why I think the point that Anshu made about maybe waiting it out in the home country is a good idea, is because of that. Because if you have been found to have lost status, if this thing turns out really badly, and like, it does turn out that, you actually have lost your status, then failure to maintain status is a bar to filing for your green card application from within the US. But it's not if you decide to leave. So the maximum grace period, well, let's not get into too much of a nitty-gritty on that. But I would just say that if you're married to a US citizen, things are a little bit easier because you do need to show you don't necessarily need to show by law, by statute, you don't necessarily need to show maintenance of status. But you do need to show a legal entry. So like, all of you, if you're here on F-1, then I'm assuming that all of you did enter legally. There's no question about that. So, and also being married to a US citizen, it allows you to file for the petition and the green card concurrently at the same time, but it's not like that when you're married to a green card holder. So there is the visa backlog and all those kinds of things to think about. Especially if you're from India or China, and like, because those countries have a very long visa backlog if you're married to a green card holder rather than a US citizen. So there are these other very specific things that you need to probably discuss with an immigration attorney to see like where exactly, like what option makes sense for you.
Yeah.
And just don't jump to leave the country without speaking, because the thing that I want to highlight is about, you should be aware about the grounds of inadmissibility and grounds of deportability, those things, Marina has already defined it, but just to repeat it, the grounds of inadmissibility these are the grounds when someone is seeking to enter the US or adjust their status here. So for F-1 students, the question of inadmissibility may arise in the situation when you are applying for a new visa or a change of status, What are the things that you have to keep in mind is whether they are a violation of immigration laws or not, that will make you inadmissible. Whether they're criminal activity, the serious crime or serious criminal conviction that falls under the ground of inadmissibility, drug-related offense, crime involving moral turpitude, we'll discuss that later, and whether they're false representation, misrepresentation of fraud documents while you're in visa application and other things. Those are the things that you need to discuss, So, and the ground of deportability is generally when F-1 students can be removed from the United States. So most of you are here, you're fearing that maybe ICE will pick me up, they will deport me. But there are certain grounds of deportability. If you fail to maintain your status, if you work without authorization, if you have violated the term of F-1, or there are certain criminal conviction. Not all crimes will make you deportable, but certain specific crimes like CIMT, crime involving moral turpitude, aggravated felonies, and drug-related offense will put you into the deportation ground. So you have to discuss about these options. And again, you're not alone. There are more than 4,700 students going through the same process, and it is unprecedented time. This has never been before. It was the DSO terminating SEVIS before, and now it's ICE terminating it. So be proactive and take steps to protect yourself rather than taking a decision in rush and closing all the doors,
Yeah.
Yeah.
And just to kind of chalk out what we've talked so far and where we're headed next, right? Just because there's a lot of information we've been sharing, and really thank you to all of our speakers. We started out with just basic understanding of what can you do as an F-1 student, and then we went into just what it means now that your SEVIS is terminated, explain the key terms, unlawful presence. And a quick note I wanted to add about unlawful presence is, these things, like Marina said, has long-term effect. Let's say in the future, you're doing green card application, you're doing EB-1, you're doing H-1B. These are things that would affect your employment ability as well, right? So anytime, and even though we're talking in the context of F-1, all of these things will have future implications, right? Like right now, we're just talking F-1, and we kind of went and talked about OPT and how that affect. Sure, the SEVIS termination may not affect you as H-1B, but some of these things that we talked about in unlawful presence, they're going to have long-term effect. They're not going to leave your record. So it's really important that you are proactive, you understand your rights, and you reduce any of, situations that this could arise. But now let's say you're F1 student, this has happened, your SEVIS has been terminated. We talked deeply about reinstatement and the nuances that's part of what it means to apply for reinstatement. We also looked at other legal options, marriage-based and others. But I think what Abhima and everybody is reiterating, the importance of this is you have to understand that none of these are an easy get out of whatever trouble card, right? These are, we're really giving you all the options in a surface level and in a high level overview. You would have to ultimately depends on case by case basis, and all the attorneys would have to delve into each of the matter, and none of this is a sure shot guarantee. So with that, let's, we kind of already talked about issuing of new I-20 with, time in our mind as well, because we're headed to, after we briefly talk about litigation, we're headed to case studies. I think all of you have brought this up as an option already. But briefly, Marina, just to wrap it up for us, now let's say reinstatement and other options are not available. I cannot avail of it. Litigation, that's where we're headed. What does that mean?
Yes, so it just, because this was essentially an unlawful action by ICE, it didn't follow the regulations that it was supposed to follow, didn't follow procedure that it's supposed to follow. It is under the Administrative Procedures Act. It is something that we would call an arbitrary and capricious decision or action by an agency. And that gives rise to a cause of action, and a cause of action in order to seek a remedy from the federal courts. So an agency is supposed to act in a reasonable manner, like it's supposed to give you due process, it's supposed to follow procedure, give you notice and time to respond, and all of those things. And they didn't do any of that. That's what it seems like for a majority of students who got their SEVIS terminated out of nowhere. That's where it seems to be, which is why, it seems like litigation is frankly the only option for some of you. Obviously, if you have like serious, violations or working without authorization, which is one of the most serious violations, I'm going to tell you that right now. Litigation is a good option. Some of our, other immigration attorneys who are very experienced in this, like they've already filed litigation in different district courts, as you might know. And at least we have, so what we're basically asking for is essentially a restraining order against the agency in order to make them stop doing what they're doing. So that's all it is. It's basically is like we're asking them to stop doing what you're doing and to basically reinstate these students back into the status that they belong, that it never should have been terminated. The relief it's a temporary restraining order for now, which is going to be like an immediate relief that is available. If it is granted, then the agency would be restrained from terminating your status. And a long-term solution for that would be something called a preliminary injunction. And if you're able to get, if we're able to get temporary restraining order, and if we're able to prove it up in the court that, like this is an arbitrary action by this agency, then a preliminary injunction would be like the permanent solution for this. And I would also like to note that there is a class action lawsuit already going on in order to stop the government from, carrying out this action. I think there is one from the National Immigration Project. There's one from the American Civil Liberties Union, ACLU. They have filed lawsuits against the government. And for some of the others, like where we're seeing these lawsuits being filed, we have received at least 3 orders of temporary restraining order being granted. I think there's one in Wisconsin, there's one in Missouri, I think. But the thing to remember for this is that litigation is costly. Like it's a lot of work, and it involves going into court and like making arguments and all of those things. It's difficult, it's costly. So one of the solutions that immigration attorneys have thought of is mass litigation. And it's not the same as class action litigation, which has its own different complicated requirements, but it's like a mass litigation, where similarly situated people can sort of group together, as long as we meet the procedural requirements for, where we're going to file the lawsuit, like which court we're going to use in order to file the lawsuit. As long as we meet those requirements, we should be able to file a mass litigation on this.
Thanks, Marina. From my understanding, litigation can be an option. For some people, might be the only option. Obviously, there are some that we are all us immigration providers are keeping an eye and how this is going to develop. This is a bit of a developing story as well. A lot of action has been taken, and but at the same time, at an individual level, if those are your options, then you can seek advice from attorney. So we talked about reinstatement, other legal option, litigation. So kind of let's go into few case studies. But before we do that, and this really any of you can take this, and very, very briefly, I think it's a good time to distinguish between a criminal attorney and an immigration attorney, and when, how do students separate those two? Sometimes you would need both. Sometimes you need a criminal attorney, sometimes you need immigration attorney. Can you guys briefly talk about when would that be? The distinction between the two.
Yeah, I can take that. So, a criminal defense attorney is somebody that is going to represent you in the criminal charges against you in the state where the criminal charges are pending. So your immigration attorney is not going to be able to do that unless, of course, they're also a criminal defense attorney. But for now, let's keep those two separate. So your immigration attorney can work with your criminal defense attorney, and they can tell your criminal defense attorney, these are the charges, this is how these are the consequences they will have for immigration of these charges. If they plead, what happens? If they're found guilty, what happens? If the case is dismissed, what happens? If the charges are dropped to a lower charge, what happens? So in an ideal world, whenever you have a criminal case and you're an immigrant, you immediately want to have a criminal defense attorney that can work with an immigration attorney, and they both can work together to make sure that however the case ends up, whether you're going to fight it, whether you're going to plead to something, it's going to not negatively impact your immigration status. In the current context, obviously, when the student, whoever was charged, you pled guilty or you took deferred sentence, whatever there's. So in every state, pretty much, there is different terms that applies to criminal cases only. So in the context now, when you're coming and speaking to the immigration attorney can advise you to go speak to a criminal defense attorney to see if there is some way to go back and fight those criminal charges even now, because some of you may not have known at that time what it means for immigration, or your defense attorney didn't tell you how it affects your immigration status. So you may have to work with a different criminal defense attorney now to fix that so that you can get out of this mess. So that's how the two interact. And while we're on this criminal case topic, I just want to briefly add that please do not expunge any of your records, regardless of what happens. A few of the students I've spoken to had their cases dismissed and their cases were expunged. And in normal world, when a case is expunged, it goes away from your record. But in immigration world, it does not go away from your record. In fact, expunging your case can create much more problems. So moving forward, please, if you have any type of criminal charges, do not expunge anything. Very important.
Yeah. Absolutely. I always recommend that if you outside of the SEVIS context, if you're ever in legal trouble, always consult an immigration attorney and a criminal attorney, because I've seen situations where the criminal attorney does not understand the immigration consequences and will say, "Hey, let's do this," and they do this, and it was a different strategy. So you do need both of those people working hand in hand. But thank you, Anshu, for providing that distinction. I think it's a really important one. So let's go into case studies, right? And this is really for all three of you, as as each of you kind of have been working on this. And I must say thank you, right? I know the last few weeks for immigration practitioners have not been easy. We've been, I have to take this moment to just recognize the sheer hard work and the countless hours that we've all put into this. Even doing this, is really coming from a heart project and a wanting something to do for the community. So I know we have all been answering many, many questions, many, many emails. So in this, and we've kind of built out a pattern earlier in like, what are some of the infractions we're seeing, right? So let's kind of parse that out. Let's start with minor offenses. What are minor offenses? What have we seen? How has that played into SEVIS termination? Some of the examples that each of you have seen, and let's keep this right now to what constitutes a minor offense and what does that mean?
You want to go for it, Avima, or?
You can take it.
Okay. So we have seen from the data that we gathered, we have seen traffic tickets, anything from like speeding tickets to running a red light to getting into an accident and having to run a red light, to just let me see what else. Some other type of violation, like traffic violation, like failure to produce an ID, or driving without a license, driving with a suspended license for some reason. There is also and then like there's also some cases, very like there are some cases where the person didn't even know that they were being followed by the police. They did something like, they made a wrong turn or something, and then they were followed by the cops, but then because they're new in the country, they didn't know that they have to stop. Like they don't know what it looks like when a cop follows you, and then that's how they got pulled over, and then that's how they got ticketed or arrested or something as a fugitive, or various things like. For some, like there were no infractions whatsoever, and that's very saddening. So like we talked about this a little bit in the beginning, but in immigration law, there are things that you do that make you deportable, right? There are these grounds of deportability that the statute lists. And unless you fit into one of those categories, you're not deportable. Like the deportability cannot be proven, or the removability cannot be proven. And then there is this whole other concept of inadmissibility, where you can think about it as it's like you're at the airport and you're asking for physical admission, right? But then like when you're changing your status, when you're filing for your green card, when you're filing for some other like non-immigrant visa, like an H-1 or something, you're still asking for a legal admissibility, right? If you have something in your history, something in your immigration history that makes you inadmissible for some reason, then that can bar you from getting those types of relief. So having said that, most of these offenses are not deportable offenses. They're not. So if you were to be arrested by ICE, detained by ICE, and put into removal proceedings, one thing that they could charge you with is failure to maintain status. And if you haven't actually failed to maintain status by working without authorization or some other way, then that charge of removability cannot be proven. So, and Abhima will likely talk about, all of those things that happen in removal proceedings, what you can do in order to get out of removal proceedings, what to expect if you do get detained by ICE and those kinds of things. That's her forte, and she'll talk about that. But for some of the serious offenses, like if you have a DUI, that's a very serious offense. That is actually something that the Department of State can use in order to revoke a visa. So if you do leave, then you're going to have to reapply for a visa and then come back in. Working without authorization is a very serious violation because it's an actual violation of your F-1 status. Other than that, like if you do have something serious, something more serious, something like a felony, something like assault, fraud, all drug convictions, like some type of drug charges, even if you were just arrested for some drug-related crimes, definitely hire an immigration attorney in order to look at your case because those are not easy. But for everything else, that's what I would stop with.
Marina, a quick question to you as you practice immigration too, because the students that we are speaking, sorry, Sammy, as when we talk with students, there are students with one DUI. Will just one DUI make them inadmissible or deportable, or there can be ways with good.
So it's not the DUI that makes them deportable. It's the visa revocation because of the DUI that would make them deportable. So it is, to my understanding, the subsection of the law is 237A1B, which is if you have if your visa has been revoked, then you're deportable. And then the second one is 237A1C. I think that's correct. If I'm not a code robot, but yeah, 237A1C, that is failure to maintain status. So that is something that would be a deportable offense under the statute. So I would say that if you have a DUI, definitely talk to an immigration attorney because even if, if your visa has not been revoked because of that, I would say that if the cases, unless you're placed in removal proceedings and you're not able to do anything about that, I would still say that it depends on whether or not the ICE decides to bring charges
against you. And it also depends upon with DUI too, what forms of DUI is that, I mean, there are simple DUIs, there are DUIs that have taken people's life or more serious kind of injuries, and, so it depends. And it's always a good idea to have criminal attorney and immigration attorney craft a strategy before you take any plea agreement, guilty plea, or any sort of, criminal defense, because it's not just about managing your criminal case, but also about understanding the consequences of that. So this needs to go parallelly. Not that, hey, my criminal attorney is doing this now, and then help me with this now. Both of the attorney need to plan and then craft a strategy that can help your immigration.
Like Anshu mentioned earlier, like I cannot stress enough, like how much, because in immigration, conviction is defined differently. Conviction is, a criminal conviction in a criminal court is not the same as how immigration defines what a conviction means. In some cases, all you really need to do is plead guilty. In some cases, all you really need to do is admit to your mistake, and that is still considered a conviction. It's defined very, very broadly. So even even if your case was ultimately dismissed, even if you did get some sort of like a deferred adjudication and then your case got dismissed, you still have that element of guilt, which makes you have those immigration consequences. So definitely, like, don't try to get to this on your own. Hire an immigration attorney.
Yeah.
And also, I've seen the pattern of shoplifting. The students that I spoke, there are shoplifting charges with minimum of $120 to maximum of any amount. But I think shoplifting also falls under CIMT and may have impact on immigration consequences. So
Can we parse out CIMT? Because I feel like we're going to hear that a lot. Crimes involving moral turpitude. Some you guys have already given examples of what falls into it, but let's give it just quick, basic understanding of CIMT and how does that affect immigration.
So I laugh because this is the juxtaposition of criminal and immigration law, which we dearly called crimmigration, it's such a it's a beast. And the concept of CIMT is it's a crime involving moral turpitude. But then what constitutes moral turpitude, or what behavior is morally turpitudinous, is defined very differently in different courts. So it's a very difficult question to answer. It depends on which state you're in, like what statute you were, which state statute you were convicted under. But then, like, broadly speaking, it's anything that is considered like morally depraved, vile. That's how the courts have, the case law has defined it. But it's like, it's something bad.
Yeah.
I don't know. It's a difficult concept to like just give a broad overview on. But
Okay.
something like theft or something like fraud, where you have a guilty conscience, where you had, it's called the mens rea. And like if you like theft, like if you have a theft charge, then that could be considered a morally turpitudinous conduct because of that element of the intent to deprive someone of their property. Like it's a kind of a complicated concept, but
It's a whole world. And I think the intent of that question was that at least people are aware of what that means. The kind of acquaint yourself with the language. But from what I understand, minor offenses, nonviolent charges, serious charges, like Abhiman said, shoplifting, or let's say, some assault, or mere speeding ticket, whatever the degree of crime is, there will be some immigration consequences, and centralizing it back to the SEVIS termination that we're seeing. You guys have seen cases where all of these things have played a role in it, right? Some with no infraction, which is rare and sad, some with minor infractions, some with some serious charges as well. So the implications have not been discriminatory. Is that fair to say?
yeah, I mean, I would say that
Yes.
that would be fair to say. Like it's like there was some red flag in the database somewhere because of any brush-in with the law enforcement, and that just like triggered.
Yeah. And how far are we going back, right? Have you guys seen like what if the crime was 2 years ago, or what if the crime was 2 months ago? Any discrepancies in that, or is it still the same?
it's from the student that were involved from 2016, 9 years ago until a couple months ago. So with simple arrests, with no case being filed or case being dismissed, any sort of arrest has triggered this thing. And talking about, just want to quickly add, domestic violence, sexual offenses falls under CIMT. And I know the students need to be, as we said, all immigration attorney keeps saying, we have to get away from any kind of getting involved in any kind of criminal activities. We have to protect ourselves if you're thinking about immigration consequences. I've also heard about cases, public intoxication. We are not allowed to do that. Ignorance of law is not excuse. You're supposed to know what you were supposed to do and what you're not supposed to do in this country and protect yourself.
Yeah. And so now, I want to kind of, for the interest of time and just this is a very big topic and we can't cover all aspects of it today. But, I think we've gotten a very good foundation understanding of what it means to be on F-1, what does SEVIS termination look like? What are some, options, reinstatement, legal options, litigation? We talked about that. We also looked at some case studies of what are the attorneys seeing, what sort of offenses, the timeline, etc. Now let's talk the three letters that all of us really dread if ICE gets involved, right? And I think now that's to you, Avima. What do we do if if a student is approached by ICE or has received a notice to appear, right? Like what we talked about earlier, what do we do? What are our rights during ICE interaction?
Well, I think Marina already defined what is NTA. Notice to appear is this means that the government has initiated a removal proceeding against you. They're trying to say that, hey, this person needs to be deported from this country, for certain things. There are certain list of allegations. And that NTA will have list of immigration violations, the time and location of your first hearing. So that is what NTA is. Now, as SEVIS is terminated, I know most of the students are freaking out. What if ICE approach me? What if ICE detain me? What's going to happen? So I will say stay calm. Do not panic. Talk with your immigration attorney. Reach out to them. Do not sign any documents, without first speaking with immigration attorney. They might ask you to sign documents for voluntary departure or sign documents that you're not aware of. So you should not be signing any documents without contacting your immigration attorney. So, and if you have received NTA notice to appear, share that with your attorney so that your attorney knows what are the charges, what are the allegations that the government has brought against you. And if there is a hearing, if you can't hire an attorney immediately, and if there is a hearing, then you are not supposed to miss that hearing, because if you miss that hearing, then there's a chances that you will be removed automatically. So those are the things. And if somebody approached you, if somebody hold you, you can ask, am I free to leave? And if you're not free to leave, if you want to remain silent, if you want to speak with your attorney, then you have right to see that. You can clearly say, I want to remain silent. I want to speak with an attorney. But you do not have to answer all the questions. You do not have to let them know where you are born, what your immigration status is. You can remain silent while you are approached by them and talk with your immigration attorney, but do not lie. Do not present false documents. Do not sign any voluntary departure documents without legal advice. And if you're detained and you're in the detention, you have right to make a call to your family members. You have a right to request a bond hearing, and you can challenge your removal in the immigration court with help of attorney. So what I'm suggesting students is always plan ahead. As your SEVIS has been terminated, you are taking steps, either doing federal litigations or planning for reinstatement, or you may have other options too. But during this time, I think it's a better idea to have that one person who have access to your personal documents, your passport, and plan B. What if you were detained? Where are the documents? Who is the family member that can help you to get out from the detention? Or which attorney is the attorney you should consult? So you need to start making plan B so that you don't panic. You can immediately take action when that situation comes. And as I said, if you are detained, You can, I mean, there are two things. You can fight by being inside the detention, or you also have right to request for a bond hearing. So bond hearing is basically if you're detained by ICE and you're facing some sort of removal proceeding, you may be eligible for bond hearing, and it is before an immigration judge. There are different kind of requirements for a bond hearing. So the factors they generally considered are if you're a flight risk or not. They'll evaluate that, whether you flee from the country, avoiding that proceeding, whether you're a danger to the community, if you have any sort of criminal history, particularly that are serious in nature, that can negatively impact your bond hearing. And they'll also see ties to the community. If you're good at your school, if you're performing good, if you have ties to the US with family or school status, maybe that's going to help you. And I think compliance with immigration law, if you've not violated immigration law, if there's no such unauthorized work, then that may influence the judge to give you a bond. And then you need affidavit or support from a family member about that they are willing to support you, provide your tax documents. There is a poverty guideline. There's certain income that they need to have as per the poverty guideline to be able to provide support to help you release in bond. And bond hearings are in front of the judges. When you hire an attorney, attorney will submit that package and you'll be able to bond it out. Generally, bond can be from 1,500 to any amount. In my practice, I've seen 1,500 to 35,000 or more than that. But in regards to SEVIS, I've seen attorneys discussing that at least there is one case where the student was bonded out when the SEVIS was terminated and was picked because of some sort of criminal offense, but they were bonded out. So there's a high chance that if you have those documents, if you can show that you're not flight risk, you're not danger to the community, and you want to fight against the allegation that government has brought against you, you can, with those records, maybe you can come outside and fight for a case. If judge granted you bond, then somebody have to post that bond and you'll be out from the detention. And then you can fight for your case with the immigration court. You'll have master hearing, where you'll have individual hearing, and you can discuss about various form of relief that you want to seek. You can challenge those allegations. So that's how it works. So getting an NTA or facing ICE does not automatically deport you or well, you have to go back. You know, there are process, there are due process. So taking immediate steps would help you explore your options, and maybe there are legal relief like Ansu discussed, Marina discussed, adjustment of status, or some other forms of relief, including anything, that are available as per the regulations. So you can explore those options.
Yeah. Something I really liked what you said, and I think there a lot of times we get involved with the legalese and the legal technicalities, and it can be overwhelming. But sometimes a simple step like creating a folder, keeping all of your documents properly. So if this happens, figuring out a point person who knows where to access all of this for you, an attorney that you've built a relation with, right? Who to call. I think that's quite helpful to kind of build that backup plan.
Why I'm saying is that somebody will put that passport in your locker, right?
Yeah.
Now you need to show the ID, original ID, to be bonded out. Who is going to have access to that locker? So have that trusted person. If your service has been terminated, have the trusted person where you can discuss all your plans, so that if God forbid, if you're in that situation, you'll have plan. You can come out, you can defend yourself. So
for the interest of time, before we go to some of our closing remarks and the support and each of you, is there anything in regards to ICE or any other things we've talked about that any of the other speakers, I'm sure Marina, want to add briefly before we kind of wrap it up?
I mean, just to add that one of the rights you also have is to not let ICE into your house. If they show up to your house to arrest you, you don't have to open the door. You don't have to answer their question. The only time they can forcefully come in to arrest you is if they have a judicial warrant from a judge. So unless they show you something that is signed by a judge, you don't have to open your doors. You don't have to let them in. You don't have to talk to them. You don't have to cooperate. Nothing.
And you can't even, without warranty, you don't even have to give your phone or let them search your car. There need to be a warrant signed by judge.
What about workplace?
Same. So they can come to they have access to any public areas in any business that's open to the public. But to come into any private areas, they need a judicial warrant. They can't just come in.
That's right.
I would
Very
just quickly say, I know this is not something that you were ever hoping to, have to deal with, but it's here. And, we do have options available. We do have remedy, because this is an illegal action for most of you. There are avenues available. So don't live in fear. Just know what your rights are, exercise your rights, and talk to an immigration attorney, and, just don't live in fear.
I think that, and that's the purpose and the intent of doing this. And before, we kind of get those closing remarks, I want to recognize all of us, right, and all the work that all of us have put in, and the hours and the time, as I said, and I think it's really critical to do that. How can people reach out to each of you? What are your expertise? What kind of cases you're willing to take? How can they contact you? Give us, let's start with Abhima, just kind of go down on my screen, Abhima, Anshu, Merina, just give us a rundown.
Well, thank you, Sammy. I basically practice removal proceedings. I represent client immigration court and bond hearings. It's a federal hearing, so I do take cases all over the United States. I can also help students. I mean, I've been doing a lot of consultation from past week or so. I've received about 50 or 60 messages to call, about 20 or 25 calls. I'm sorry if I'm not able to answer everyone, because I have my full-time job. I have full-time commitment, my daily court hearings, and I'm trying to do a free consultation, but I can't take all calls because of my other commitments. And I have a toddler, a 3-year-old daughter who demands my time, so I have to balance. But I'm trying my best to answer your call. I can definitely help on reinstatement, on helping clients to prepare their package. And also, if you ever need help, if you're detained by ICE, you can definitely reach out to me. I work for Chetri & Associates. I can be reached out at my email address is my initials AU at chetrylaw.com, CHETRYLAW.com. You can also reach out, put my number in. If you're detained, if you need help, if you need to speak with an attorney, you can call me at 646-640-6022. You can ask your family members to reach out to me, and then we can coordinate, and I'll be happy to help you, happy to represent you in your matter.
Thanks, Abhima. Anshu?
Am I next? Okay.
Yes.
So yeah, so I can definitely help with reinstatements. I also do removal defense. So if you are picked up by ICE and you need help, you can contact me. I can help you with bond as well as for, just in removal proceedings. Federal litigation, I can only do it in Maryland. So if you're a student that's impacted in Maryland, for now, those are the only students I can represent in the lawsuit. So the email to reach out to me is info@anshukarkilaw.com. I'm on Instagram, TikTok, Facebook. If you just search Anshu Karki Law, you will get my page. You can send a message there, and reach out to us.
Thank you, Anshu. Marina?
Okay, so I do most of everything, but for our purposes, I would say that I am looking for plaintiffs. I do plan if we have enough interest and if we have enough number of plaintiffs in order to um, get this thing done. I would like to. I can be available to do a mass litigation or individual litigations depending on what your specific situation is. What I need to know from you in order to determine whether or not we can do this litigation is where you live. Your address is going to be the most important thing. If you live in the in the greater Houston area, I would definitely ask you to reach out to me. I am also on Facebook, I'm on LinkedIn, I'm on Instagram. I also started it's my own practice, like Shakya Immigration Law. And if you search me on any one of those social media platforms, you'll find my email. My email is mshakya at silawpllc.com. So just Google me, Shakya Immigration Law. Make sure you spell my name correctly, Shakya. And then you'll find me. And my email is everywhere. My email, my phone number, my cell phone, everything is everywhere. I will, however, say that I am a solo, so like I may not be able to get to everybody. I know this is it's because so many of you are affected by this. Like I will, if I can't get to your case, then I will definitely refer you out to very competent immigration attorneys. There are a lot of us, and you don't have to stick to us. You can go to, basically anybody that you feel comfortable with. But yeah, yeah, that's how you can reach out to me.
And I think this question and why I wanted to kind of address this was it's really important as students for you to understand and know and have a book of, contacts available for attorneys and know who does what and how each of us are distinguished in our expertise, our specialties, because those things do matter. I am also Houston based. I work for a firm called Immigration Mobility Solutions. The partner at my firm does help with reinstatement, but our specialization is mostly employer based. So if you're an employer and you want to now understand some of these things from an employer perspective, that's something we can help in terms of strategy and guidance. But we do mostly employment based NIWs, EB1s, an array of things. I would not be able to help you with litigation, but if you were to contact me, I would send you to one of the experts. So with that being said, I think again, what Marina said, I wanted to echo this, and I want to give time for speakers to give closing remarks as well. But it's really unprecedented times, and it's difficult. We get it. Our intent here was to provide and give some information, foundational information, but enough for you to feel empowered to navigate this uncharted territory, and know where and how you can seek these resources as well. So before we close this, and again, thank you so much to really all the speakers and the work and labor that went towards coordinating this very last minute, very urgent. We wanted to put something together for the community. I appreciate our collaborating partners and the organizations who helped put this through. I appreciate all the students and everyone that has come. So with that, let's just start with Anshu, give your closing remarks, any, final takeaways, and then we'll go to Abhima and Marina.
So all I will say is that obviously it's a very stressful time, like for all of us. We as attorneys, we're all trying to do the best we can to serve our clients, have our business, and maintain our own sanity as well. Obviously, it's much more stressful for you if you're a student going through this situation. But I truly believe either it's through class action or a bunch of these mass actions being filed, like something this will not go on this way is what I strongly feel. So, hang in there. Whatever you feel comfortable doing, reinstatement, like get something in, lawsuit, reinstatement, whatever. But I do think that we will soon hear about some sort of resolution for this, because I mean there has to be a solution. So don't lose hope.
Abhima?
As Ansu said, and I've said it earlier too, to all the students who are affected, you're not alone. Don't think that it's just you. And it's sad, it's happening. We are sad. And there are more than 4,700 students going through this. Don't be passive. Don't take steps. Be proactive. Don't just think about, oh, I don't have financial means to reach out to attorneys or take actions. If you have financial means, reach out to attorneys. There will be certain fee. If not, try to find pro bono or low bono attorneys who can help you. But definitely get help. And uh, even if service has been terminated, if you have not done anything wrong, if you think you can still defend yourself, you can strongly defend yourself. You have that due process. Here in the United States, as Marina highlighted, Ansu highlighted, there is a federal litigation. You can take action. There is a reinstatement and other relief. But please don't be passive. Be proactive. Take steps. Talk with attorneys. Talk with DSOs and help yourself to fulfill your dream. But don't be sad. Don't be depressed, and just put yourself in a room without doing anything, because nobody can help you if you don't take action. So I want you to take action and fix the issue. Hopefully justice prevails. Hopefully with these mass litigations and the class actions, these issues will be resolved. We will fight for it, and we will help you as much as we can.
Marina?
I would like to take this opportunity to, of course, thank you all for joining us and then participating and sending all of your questions and everything else to us. I would like to take this opportunity to steer you away from doing anything illegal, doing anything by fraud, doing anything out of the ordinary. So you are F-1 students, okay? And your status means everything right now. Everything that you do, all the actions that you take, everything that you say, and everything else, it's going to affect the rest of your life. This might just be a little blip in all of your immigration history, and whatever you do now always has long-term consequences in immigration. So if you're driving, be careful. If you don't break any law, don't give the law enforcement any reason to, arrest you or, stay out of trouble is what I would say. I think, and yeah, I mean, I would just say, just don't do, there's no shortcut to this. There are avenues of relief available, but there are no shortcuts. Don't fall into the trap of filing a fraudulent application, going for asylum application when you don't have a meritorious claim for asylum, or going into a marriage-based, filing a marriage-based case when you don't have a bona fide relationship, when you don't have a bona fide marriage. I promise you, it'll come back to haunt you. And it's only going to make things worse. So that's my final say.
Thank you so much. Thank you, all three of you. Thank you, all the students, and just everything that is what is happening right now. I think it's important to recognize. All of our information has been put in the chat. Again, our names are part of the flyer. I will repeat the names, and I'm sure all of us can be found on LinkedIn and have our website. So if you could jot down the names, you will find our phone numbers and our websites pretty easily. It's Attorney Merina Shakya, Merina, last name Shakya, Attorney Anshu Karki, Anshu Karki, Attorney Avima Upreti, Avima Upreti, And me, Sami Adhikari, SamiAdhikari. I think all of us are on LinkedIn. All of us have websites, so you can find us there and contact as it's needed. We hope to do more collaboration and more videos or webinars as as things become more critical. Just know we are also following the trends and we're doing our best to bring the information to the community as quickly as we can and as the best as we can. Sometimes some things have to be urgent and quick. So that's what today's was. Thank you. And that's all we have for today's session. I would ask the speakers to stay back just quickly, but the audience member, you're more than welcome to drop, and I'll be stopping the recording at this time.